Another step in the U.S. Supreme Court case deciding if Donald Trump can be on the ballot here in Colorado.
The party that wants Trump out of the race filed a brief today. It urges the U.S. Supreme Court to follow the lead of Colorado Supreme Court justices and bar Trump from the primary ballot.
Denver 7 reporter and attorney Jessica Crawford on this one for us tonight. Jessica, the brief had some pretty strong words in it tonight.
Yes, it did. So we're going to take a look at that right now. This is the brief where plaintiffs are really making their argument now that the Supreme Court has taken up the case. And they doubled down on their stance that Trump participated in an insurrection and is therefore disqualified from being on the ballot, saying in part, spearheading a violent attack on the Capitol in violation of his sworn oath to defend the Constitution. Trump disqualified himself from holding public office. It went on to say Trump intentionally gathered, agitated, and incited a mob, resulting in injury, death, and mayhem. Now, the First Amendment does not protect such incitement to unlawful conduct. But there was one statement in particular that caught the eye of Secretary of State Jenna Griswold. She says that the plaintiffs used Trump's own words against him.
Donald Trump basically said that there would be chaos and bedlam if he was removed from the ballot. We saw in the voters' brief that they also mentioned that the chaos actually would come if someone who is disqualified is allowed to be on a ballot and then elected.
Now Donald Trump is getting his chance to respond. The highlights of his argument are likely to include that the January 6th attack on the Capitol wasn't an insurrection, and if it was, that as a former president, he wouldn't be disqualified from the ballot. Professor Ian Ferrell of DU's Sturm College of Law explains.
There will be a chance, by the way, for Trump to write a rebuttal brief to this reply brief, and so he kind of has the last word. But that brief has to be a bit shorter, and then we'll have oral arguments.
Now, those oral arguments are set for February 8th, and we're expecting to get a decision before Super Tuesday, March 5th. That's the day when the greatest number of U.S. states hold primary elections and caucuses, including Colorado. In the studio, I'm Jessica Crawford, Denver 7.
Thank you, Jessica. And the High Court is considering an issue based around the 14th Amendment insurrection clause for the first time. It says officials who have, quote, engaged in insurrection are not allowed to hold office. The amendment was adopted in 1868 following the Civil War.